Good morning. Such an honor to be here, and thank you, Nina, thank you, Roger, thank you, Patrick, for welcoming me. I must begin by saying that it was very humbling and to listen to the in memoriam this morning. A lot of sober admiration for all those folks. And then it also dawned on me that that bodes well for my longevity as a member of this organization. So hopefully there's some cause and effect there. It is true that I am chairman of the board of that other honorary society based in Cambridge. John Adams and Ben Franklin were well-known rivals. One commentator I read wrote that to Franklin, this is this person's words, to Franklin, Adams was a paranoid, arrogant, by-the-book nuisance. To Adams, Franklin was a lazy, immoral, cunning phony who hogged the spotlight. It's nice to see how far we've come since those days. So I had planned to give some remarks on how decision processes affect outcomes on multi-member courts. But lately it seems that everyone I encountered asks me with some urgency some version of the question, can the courts save democracy? I'm guessing many of you have this question, so I have decided to toss my script and pivot to this topic. The Supreme Court began its new term this past month, last month, and it has at least 3 major cases on its docket challenging assertions of presidential power. One is the tariff case, which was argued last week. A second one has to do with whether the president can remove a Federal Reserve governor or a member of the Federal Trade Commission without cause, which will determine the fate of so-called independent agencies in our government. The third asks whether the president can deploy the National Guard in Chicago. And many people expect the court to take up a fourth case on the meaning of birthright citizenship under the 14th Amendment. Can the court save democracy? Well, that's not exactly a yes or no question, but the idea seems to be that democracy depends on the rule of law, and it's the job of courts to enforce the law, even when, or maybe especially when, it is transgressed by a zealous executive. That idea, of course, has particular resonance given the history of our country, the founding history. And I bet a nickel that somewhere in the briefs and opinions in the cases I just mentioned, there will be a citation to Marbury versus Madison, and its most famous line, it is emphatically the province and duty of the Judicial Department to say what the law is. This quote is a favorite teaching tool for constitutional law professors because of its choice of words. First, it's the job of courts to say what the law is, not what it should be. In other words, description, not prescription. But is that really possible when what the law is deeply contested? Second, it's the job of the courts to say what the law is. But what law? Of course, courts must interpret ordinary laws like statutes, but is the Constitution law in the ordinary sense? And how does one say what the law is when it comes to vague provisions like freedom of speech or executive power? And what about natural law? Does it have a role in judging in our current era of legal positivism? Third, it is emphatically the province and duty of courts to say what the law is. Does that mean always? Are there questions of law that courts should not resolve? Should courts say what the law is even when they can't provide an effective remedy? And are courts the only branch of government with the province and duty to say what the law is? Okay, so this is more than we can tackle in 30 minutes, But I mention these questions to suggest that many of the issues relevant today have always been with us since the beginning of the country. And Marbury, which is now cited as authority for the power of judicial review, did not in fact settle whether, when, or how courts are to say what the law is. Marbury was a contest between the court and the executive branch, so it's worth a brief trip, I think, down memory lane to discover any lessons it might hold for today. This will be review for some of you, the lawyers in the room, the historians and such. Hopefully it will be of historical interest to all of you and maybe a kind of level setting for your observations about the legal system and the court for the years to come. So as many of you know, the events at issue in Marbury occurred in 1801 in the aftermath of a presidential election that made Federalist John Adams a lame duck as Republican Thomas Jefferson prepared to take office on March 4th of that year after defeating Aaron Burr on the 36th ballot in Congress. The election had also flipped Congress to Republican control, and Adams, in his waning days, sought to make the judiciary into a Federalist stronghold. On January 20th, 1801, Adams nominated his Secretary of State, John Marshall, to be Chief Justice. Marshall was actually Adams's second choice, after John Jay, America's first Chief Justice, declined to re-up for the role. Marshall was confirmed and took office on February 4th, but continued to serve as Secretary of State concurrently until the end of Adams's term. Imagine that. Next, Adams got Congress to pass two pieces of important legislation in the lame duck. One was the Circuit Courts Act, creating 16 judgeships to be filled all by Federalists, which they did. And the other was a statute authorizing Adams to appoint 42 justices of the peace for the District of Columbia and Alexandria. The Senate confirmed all 42 on March 3rd, one day before Jefferson's inauguration. Adams signed the commissions. Marshall affixed the United States seal to all these commissions. And then around midnight on March 3rd, Marshall's brother, James, scrambled to deliver all these commissions, but 4 went undelivered. And one of these belonged to a Georgetown businessman named William Marbury, who had campaigned for Adams. The next day, Jefferson took office with Marshall administering the oath. A side note is that Marshall and Jefferson were related. Their mothers were first cousins. It's a very small country back then. Yeah. Jefferson then promptly ordered his new Secretary of State, James Madison, to hold all the commissions that had not been delivered. Okay. So, on December 16th of that year, 1801, Marbury filed suit in the Supreme Court of the United States seeking a writ of mandamus against Madison to compel delivery of his commission. Now, a writ of mandamus is just a fancy word for a court order compelling an official to do a duty that he has failed to do. The court set the case for argument in June of 1802, 6 months essentially after the filing. But in early 1802, the Republican Congress, new Republican Congress, seeking to undo Adams's lame duck maneuvers, repealed the Circuit Courts Act, rescinding the 16 new judgeships held by the Federalists, and for good measure, eliminated the entire 1802 term of the United States Supreme Court. What we are doing today is child's play, I'm going to tell you, compared to what they did back then. And they did that to prevent the court from hearing any case testing the constitutionality of the repeal of the Circuit Courts Act. Okay. That is why Marbury's suit, filed in 1801, was not heard and decided until 1803, They skipped a year. Okay. And at the hearing, which was in February of 1803, only Marbury's lawyer appeared. Madison, on Jefferson's instruction, did not acknowledge the suit at all, not even through counsel. Hence the dilemma. If the Federalist Court ruled for Marbury, it would look political. It was clear that Madison would ignore the ruling, and the court had no way to enforce it. But if the court ruled for Madison, then Jefferson would have prevailed by doing nothing, and the court would appear powerless to check the president. Okay. The decision was announced only a couple weeks after the hearing on February 24th in 1803, with Chief Justice Marshall reading it aloud in the living room of the Stells Hotel in Washington, D.C., where one of the justices, Salmon Chase, was confined because of illness. The opinion is quite long, and apparently it took 4 hours to read. Marbury versus Madison is, of course, considered a great decision, but whatever might be said in its favor, it is not widely regarded as an exemplary work of legal reasoning. And let me explain why. Chief Justice Marshall's opinion covers many issues. I'll mention just a few. The first question Marshall addresses is, does Marbury have a right to the commission? Now, addressing this issue as the first one is quite odd in several respects. Whether Marbury had a right to the commission is obviously at the heart of the case. It is what we would call the merits of the controversy. But there are at least two preliminary issues that Marshall arguably should have addressed first. The first of those is, should Marshall have recused himself? Marshall was not just a percipient witness to the underlying events. As Adams's Secretary of State, he was personally involved in the issuing of the disputed commission, and his brother James was tasked with delivering the commissions and failed to deliver Marbury's. So it appears that there were some potential conflicts of interest that would, at the very least, under kind of contemporary sensibilities, require disclosure, if not recusal. Okay, but it's a small country, so this issue goes unmentioned in the opinion. Second, and maybe more importantly, as every judge knows, the first question before reaching the merits of any case is whether the court has jurisdiction over the controversy. If the court lacks jurisdiction, then the case must be dismissed, and the court has no authority to decide anything on the merits. And here there were two issues that suggested a problem. The first is that Madison did not appear, signaling that he and Jefferson believed the court had no jurisdiction over them at all. And second, the case was brought as an original action in the Supreme Court, meaning it was not an appeal. Marbury went directly to the Supreme Court as his first and last resort. And the irony of all of this is that the ultimate holding of Marbury versus Madison is that the court did not have original jurisdiction over Marbury's suit, and thus the suit had to be dismissed. But Marshall decides a number of issues going to the merits of the case before concluding that the court, in fact, has no power to do so. Okay. On the merits, Marshall says Marbury had a vested right to the commission once it had been signed and sealed. But, as Stevie Wonder might say, channeling English common law, why isn't signed, sealed, and delivered the correct rule? In other words, why isn't delivery required to consummate, right, the commission, making it official? We don't know why Marbury's commission went undelivered when 38 others were successfully delivered. But isn't it possible that the Adams administration changed its mind, or at least prioritized the other 38? Shouldn't the court have required some evidence that non-delivery didn't mean that Adams had changed his mind? And again, what about the fact that Marshall was personally involved in these events. Moreover, even if Marbury's commission became official when signed and sealed, why didn't Jefferson have the power to revoke it? The office Marbury sought, which was Justice of the Peace, was not an Article III judge with life tenure. It was akin to an administrative judge. Marshall says the statute creating the position established a 5-year term of office independent of the executive. But whether Congress can insulate executive appointees from presidential removal is the very issue the Supreme Court will decide this term in the Federal Reserve and FTC cases, and Marshall does not discuss this in any detail. Okay, having concluded that Marbury has a right to the commission, Marshall next asks whether Marbury has a remedy against Madison. And here Marshall states the general maxim that where there is a right, there is a remedy. And he says a remedy does lie against Madison because he is an officer controlled by law, namely the law that gave Marbury a vested right and a statutory 5-year term. Okay, but this again begs the question whether the president has authority to remove executive appointees at will, regardless of Congress. And it also does not address the issue of official immunity. Is Madison, as Secretary of State, immune from liability for his official acts carrying out the president's orders? And if liability exists, can the court order a high official to take a specific action, like delivering a commission, as opposed to simply awarding compensatory relief like damages? Okay, none of this is deeply examined. And so now, having concluded that Marbury has a right to the commission and that Madison is a proper defendant to provide a remedy, Marshall next asks what law authorizes the court to grant a writ of mandamus in an original action of this sort. His answer is that the Judiciary Act of 1789 provides this authorization. Now, I'm not going to go into the details, but trust me when I say that Marshall's reading of the statute is a stretch. Section 13 of the Judiciary Act describes what cases are in the Supreme Court's original jurisdiction and what cases are in its appellate jurisdiction. Section 13 mentions mandamus exactly once, but it is in a sentence about the court's appellate jurisdiction. The statute is easily read to say that the court's appellate jurisdiction includes a mandamus action, or, more broadly, it can be read to say that the court can issue a writ of mandamus when it otherwise has original or appellate jurisdiction. But it is very hard to read the statute as independently conferring original jurisdiction on the Supreme Court over mandamus actions against federal officers, as if such suits were themselves a type of action within the court's original jurisdiction. Yet, that is exactly how Marshall reads this statute. And why? Well, here we come to the punchline. Having construed the Judiciary Act to mean, somewhat countertextually, that Congress gave the court original jurisdiction over mandamus suits against federal officers, Marshall now asks whether it was constitutional for Congress to do so. Article 3 of the Constitution, which governs the judiciary, says the Supreme Court, quote, shall have original jurisdiction in all cases affecting ambassadors, other public ministers and consuls, this means representatives of foreign nations, and those in which a state shall be a party. Okay, Marbury versus Madison is not such a case. It doesn't involve ambassador, doesn't involve a foreign representative, and state is not a party. Okay. Article 3 then says that in all other cases within the court's purview, the Supreme Court shall have appellate jurisdiction, with such exceptions and under such regulations as the Congress shall make. Okay, Marshall reads this constitutional language to mean that the Supreme Court's original jurisdiction is defined by the Constitution and Congress may not add to or subtract from it. But another sensible reading is that Article 3 established a default allocation between the court's original and appellate jurisdiction, while giving Congress the power to reallocate those cases by making exceptions. That's stated in the language of the provision, which is arguably what Congress did in the Judiciary Act when, according to Marshall, it conferred original jurisdiction on the court to hear mandamus actions against federal officials. Okay. But Marshall instead concludes that this addition, Congress's addition through the Judiciary Act to the court's original jurisdiction is not consistent with the limited list of cases, the ambassadors, public counsel, state shall be a party, that Article 3 places in the court's original jurisdiction. Thus, Section 13 of the Judiciary Act is unconstitutional, which means the court had no power to hear Marbury's suit, and the suit, therefore, must be dismissed. Okay. If the last part was hard to follow, don't worry, there's no exam here. It's not important. What's important is that Marshall asserted the power of the court to hold an act of Congress unconstitutional, and asserting this power of judicial review enabled the court to avoid a great embarrassment, right? For Marshall, because Marshall knew that Madison and Jefferson would not comply with any ruling in Marbury's favor, and yet a ruling for Madison in a suit where Madison did not even show up would have revealed the court's impotence against the Republican-controlled political branches. In the end, Marshall did rule for Madison by dismissing the suit, but he did so by asserting the power of judicial review as one of the checks and balances in our constitutional system. To say this, however, overstates the actual holding of the case, because the constitutional holding in Marbury had to do with the Supreme Court protecting its own jurisdiction against interference by Congress. So, arguably, the only principle of the Marbury case is that each branch of government, in the exercise of its own prerogatives and in the conduct of its own affairs, may interpret the Constitution for itself. But that is different from saying that the interpretation of any one branch is binding on the others, or that the court is the final or exclusive arbiter of the Constitution's meanings. Those broader propositions were not established in Marbury, and instead they have evolved over decades and centuries of practice, and as we've seen in the headlines, they are contested even today. So I offer this founding era history not only because it especially befits the American Philosophical Society, but also because I believe we are experiencing our own Marbury moment today. A vigorous executive with a compliant Congress is upending norms and pushing the boundaries of the law. Many Americans are wondering if our courts can serve as an effective check and vindicate the rule of law. The Supreme Court faces a test of its own legitimacy. It is, of course, the court's job to say what the law is, and it must do that job, but it is no more capable of enforcing its judgments against a recalcitrant executive than the Marshall Court was over 200 years ago. The tariff case exemplifies the dilemma and choices facing the court. The court could hold that tariffs are taxes and Congress can't delegate the power to tax to the president. It could hold that Congress can delegate such power to the president, but did not actually do so in the relevant statute. It could hold that Congress did delegate such power by statute, but the president did not exercise the power in accordance with the statute's terms. Or it could hold the president did properly exercise his statutory power, or it could hold that the president, regardless of any statute, has power to impose tariffs as part of his constitutional authority to conduct foreign affairs. All these options are possible. If the court rules for the president, Will it be seen as capitulation? And if the court rules against the president, can it order a refund of unlawful tariffs? Or is there some other meaningful remedy that it could devise? Well, as in Marbury, the legal issues are murky, and there is not much precedent to guide the analysis. Yes, it is the court's job to say what the law is, but that is almost misleading as a description of the task. The Marbury decision leaves much to be desired in terms of legal reasoning. It is unconventional, full of contestable assertions. It does not exemplify strict construction of legal texts. Arguably, it has only a tenuous claim to correctly saying what the law is. But it is also a masterpiece of judicial craft and strategic judgment. It is a brilliant decision. So hence, the greatest irony of the Marbury case is also perhaps its greatest lesson. Chief Justice Marshall, in his determination to declare that it is emphatically the province and duty of the judicial branch to say what the law is, demonstrated beyond peradventure that the job of the courts is far more layered and complex than what that statement would have us believe. I'm going to stop there and entertain your questions. Thank you very much for your attention.
After that exceptionally exciting and almost spellbinding talk, unexpectedly so for me, I'm thrilled to entertain questions. We have a lot of sharp legal experts and as well as many people interested in the Supreme Court and the law in general. We have a question over here. Please identify yourself when the mic comes to you, and please state where you're from. So before...
Yeah. Again, I'm Tom Klein, an emeritus professor at the University of California, Berkeley, and a spouse of a member. You've added to the terror we've all had at realizing that what we all grew up being told were checks and balances are sort of a fantasy, that when push comes to shove, where are the real checks and balances? And I'm wondering, are you of the opinion that there really is an urgent need to establish a whole set of constitutional amendments to make these things more specific and concrete? And what amazes me is I know there are groups trying to push for constitutional amendments, but I don't think they're having any effectiveness at all. And I don't know whether that's just a misimpression. Do you think there's any hope of actually making the Constitution so it has the kinds of checks and balances that we all assume? That this is amazing. We were all taught Marbury versus Madison. That's what it was. This is fascinating to learn how wishy-washy in a sense it was. But what is your opinion on the hope for constitutional amendments to try to make these things safe? The Supreme Court, this is the job, and the president has to obey or he will be impeached or whatever.
Yeah. Thank you for the question. So I live in the Berkeley, Oakland area, and it's an area where I see bumper stickers that say things like, overrule Citizens United. That's like a bumper sticker, or let's have a constitutional amendment, right, to overrule. It's funny how that decision is so well known in the popular lexicon. And when people think about constitutional amendment, a lot of people go to that. I don't think constitutional amendment is realistic as any near-term solution. One of the problems of any notion of a constitutional amendment is that it opens up a wide field of endeavor for anybody who has a beef with any part of the Constitution. So it's very hard to conceive of a constitutional amendment process that is limited in scope to maybe what you and I might be concerned about without opening up to everything else. However, that said, I will say that one thing that caught my eye in the last few months is that a scholar who I really respect and enjoy, have a good friendship with, is Jack Goldsmith at Harvard Law School. And Jack is a a presidential power scholar, among other things. And for quite some time, I think he had been of the view that, the checks and balances, they will kind of work themselves out, and we have to take a deeper understanding of the checks and balances to include a lot of the things that you don't learn in, like a lecture like this. It's not Civics 101. It's more the internal norms, right, including of the Justice Department and of the way in which our government works that have accreted over time. And those informal norms, as much as hard law, play a very important role in the checks and balances. Well, notably for me, because he is someone who had been very much of that view, he has been caused to re-examine his view by events, and he has floated the idea of an amendment, especially to Article 2 of the Constitution. Now, just a brief word, Article 2 governs the presidency, or more generally, as it's said in the Constitution, the executive power. It was written as Article 2 because our framers believed, I suppose, in legislative primacy. Article 1 governs Congress, 2 is the president, and 3, almost like afterthought, is the court, right? So that signals something. But of course, over time, these power relations have become inverted. There's no question that the president is the most important political actor in the system that has evolved. And there are many reasons for that. You can chalk it up to numerous exigencies that have occurred over time and the accretion with each one, assertions of emergency and then claims of power that never then dissipate. The vast expansion of the administrative apparatus of the United States, largely through the New Deal and then continuing forward, the rise of the president as a party leader, the vertical integration of the political party structure, which kind of diminishes the significance of federalism, the advent of modern technologies, which make the bully pulpit more strong than no one really, with all apologies to our very able leaders in Congress, people don't really tune in to listen to what Chuck Schumer or John Thune have to say. But they will tune in to the president, right? There isn't such a nebulous, basically the presidency, and I should have added world events to that. The presidency isn't just sort of like a roving commission to fill in essentially any gaps in the power vacuum that exists. And that is essentially what it has become. And as against slow-moving courts like mine or any courts, a vigorous, nimble, energetic executive is a very tough match, a very tough match.
Sorry, I didn't see you, Rogers. We'll get you just a second.
Gene Fidel from Stockbridge. One of the things that strikes me is that, and congratulations on your talk. One of the things that strikes me today is the interaction between the court and its audience. This is an environment very different from the environment in 1803. It's possible because of social media and so forth for members of the public to follow with great, very closely the issues before the court. And people are pretty strung out about the current caseload. What was the story in 1803? Going into the decision, was Marbury v. Madison
an object of active political interest in the newspapers, for example, or the court's then audience? And what was the public reaction to the decision?
So I can't answer these with great confidence, but one thing I will say is that for Marshall, he was keenly aware of the political stakes going into the decision, primarily because of the repeal of the Circuit Courts Act and the elimination of the Supreme Court's 1802 term the previous year. So he was put in a very bad position because the new administration and the new Congress were obviously willing to maximally exert pressure on the judiciary. When I say, I was sort of joking that what we're doing today is child's play. It's not quite joking. I mean, suppose today that a Republican Congress, in order to avert court rulings on a current president's policies, or I shouldn't say Republican, it could be any Congress, eliminated an entire term of the Supreme Court. Wow, that would be more than a nuclear option, right? So I think it was unmistakable in terms of the environment. In terms of the aftermath, there's no question, I think, that the Jefferson, who nominally won the suit, continued to sort of test the boundaries, shall we say, including the other issues that were very alive at the time. For example, the Alien and Sedition Act was a very live issue at the time. Jefferson pardoned all the folks who were convicted under the Alien and Sedition Act. Does this sound familiar? And the constitutionality of the Alien and Sedition Act was not really examined in great depth. So it was a very politically treacherous time. It's very hard to make historical comparisons in terms of some metric of how threatened or threatening the different branches were toward one another. But one could say that the court, at least, was a very fragile institution at the time. It did not, of course, have the august building and the trappings of power, that we come to see it as having today. That's a very modern phenomenon, as you know. And so the idea that the small group of people writing these extremely lengthy decisions could somehow wield power on a co-equal basis, right, with an energetic executive. And by the way, it was so partisanly split. I think that it's no accident that the court did not hold any other act of Congress unconstitutional for another 50-something years, and that was in Dred Scott, which invalidated the Missouri Compromise of 1820, not exactly the court's finest moment. So, yes. Yeah.